Bismillah, walhamdulillah, wassalatu wassalamu ala rasulillah, wa ala alihi wa sahbihi ajma'in. So this is the second part of our course dealing with Islamic jurisprudence, or the principles of deriving rules and regulations from the source materials of the book and the sunnah of the Messenger Muhammad sallallahu alayhi wa sallam. We started last week by discussing the definition of a hukum. Because Usul Al-Fiqh is really dealing with deriving Aḥkām, rules and regulations, the first thing we wanted to do was to find out exactly what a hukum was. What is it that we're talking about when we talk about Aḥkām, rules and regulations? And we defined this hukum to be خطاب الشارع المتعلق بأفعال المكلفين. That it is a communication coming from the shari', the lawgiver, concerning the acts or the conduct of a legally responsible person, a mukallaf. So we said it's communication coming from the lawgiver. This communication is either from Allah or His Messenger alayhi salatu wasalam. So it's a communication, the source of which is revelation. The shari', the lawgiver. When we talk about lawgiver, we are talking about Allah and His Messenger sallallahu alayhi wasallam, and anything that's built upon the words of Allah and His Messenger, like ijma', consensus. So in the context of Islamic law, in the context of Islam, what is halal and what is haram, we are not concerned with the words of anybody save the words of Allah and His Messenger sallallahu alayhi wasallam. So we are not concerned with the opinions of people. We are not concerned with the traditions and the cultural practices of a particular nation of people. When a person says this is the ruling or in Islam, this is haram, this is halal, this is wājib, our first question must be, show me where Allah and His Messenger said. We're not concerned with, did my parents say? Does my tribe say? Does my culture say? We are concerned with, in terms of rule givings, in terms of rulings, what does Allah and His Messenger have to say about this? Because when a person says, this is haram, this is wājib, he is saying, in effect, that the ruling with Allah subhanahu wa ta'ala about this act is that it is prohibited. Or the ruling with Allah subhanahu wa ta'ala about this act is that it is wājib. This person is effectively speaking on behalf of Allah subhanahu wa ta'ala. This is the role of the faqih, the scholar, the legal jurist in Islam. It's an incredible responsibility to be saying this with Allah subhanahu wa ta'ala is halal. This with Allah subhanahu wa ta'ala is haram. And therefore, we have to ask the question, if this is a ruling with Allah or His Messenger, show me from the words of Allah and His Messenger where this ruling is. So we are only concerned in Islamic law with Allah said, His Messenger sallallahu alayhi wa sallam said, or a consensus based upon the words of these two. So it's a communication of the shari', the lawgiver, concerning the conduct of a mukallaf. Who can remind us what a mukallaf is? What is it that's required for a person to become legally responsible in the eyes of the Islamic law, in the eyes of the Sharia? He is baligh, meaning?
He's attained puberty.
He's past the age of puberty, yes? Yes.
Muslim.
He's a Muslim, or she's a Muslim. He's sane, or she's sane. And they have the ability. Once these four conditions are met, then the rules of Islam are applicable to that person, meaning he becomes now responsible legally in the eyes of Islamic law to enact, to follow the laws, the good do's and don'ts that Allah has legislated. So the hukum we're talking about, khitab al-shari', a communication coming from the lawgiver, al-muta'alliq bi'afal al-mukallafin, which is concerning the conduct or the acts of the legally responsible person or legally responsible people. When we talk about Aḥkām or rules and regulations, they're generally divided into, or this hukum is generally divided into two broad categories. And they call them al-Ḥukm al-Taklīfī and al-Ḥukm al-Waḍʿī. Al-Ḥukm al-Taklīfī refers to defining law. It's translated as defining law. And it deals with acts that a person is directly commanded to do. al al-Ḥukm al-Taklīfī, acts that a person is directly commanded to do. The word taklīf means burden. And the mukallaf is the one who has this taklīf applied to him. Now, the word burden in English it has negative connotations. It makes something sound onerous, it makes something sound difficult, it makes something sound like, oh no, I have to do this as a, you don't want to do it, you have to do it. In Islam, when we talk about taklīf, the laws of Islam are not difficult. Allah subhanahu wa ta'ala does not obligate things upon a person that are difficult for him or her to do, that are beyond that person's ability to do. The laws of Islam are not difficult. They're not onerous. In fact, we are required in Islam to energetically and willingly fulfill the rules and regulations of Allah subhanahu wa ta'ala. But they are a burden from one aspect. And that is that a person becomes responsible for those acts. If he doesn't do them, he faces the consequences of not doing them. If he does do them, he faces the consequences of doing them, be that halal or haram. So al-Ḥukm al-Taklīfī refers to the defining law. The laws, the actions that a person himself is required to do, such as you must pray. This is something that each and every single one of us is required to do. Such as zakat, such as hajj, such as fasting the month of Ramadan, such as you must not drink alcohol, such as you must not do drugs. These are all commands and prohibitions that come under the individual responsibility of that person. And they fall into 5 categories. The acts that are taklīfī fall into 5 categories, which we all know. Either it's wājib, obligatory, either that act is haram, prohibited, either that act is mustaḥabb, recommended, either that act is makrūh, disliked, or that act is mubāḥ, meaning permissible. This is the first category of al-Ḥukm, rulings. Al-Ḥukm al-Taklīfī, the law which defines, if you like, the extent of man's liberty of action. The extent of man's liberty of action. What can I do? What can't I do? Where's my liberty? Where's the boundaries for what I can and can't do? The second type of hukum, al-Hukm al-Waḍʿī, which is translated as declaratory law. And this is talking about Aḥkām, where something is needed for an obligation to be fulfilled, or something is needed to make something else obligatory. So we're talking about relationships of cause and effect. There must be something causing another act to come into existence, or there must be a condition that's met in order for that act to become obligatory. So we're talking about relationships between the prerequisites for an act and the actual act itself. So what is the prerequisite for an act? This is called al-Hukm al-Waḍʿī, the things that are needed for an obligation to become fulfilled. And they can be either a sabab, a cause, or a sharṭ, a condition. I'll give examples of these. Or a māniʿ, a hindrance or a barrier. And this, in that poem of Usul Al-Fiqh, is codified or versified as ثُمَّ خِتَابُ الْوَضْعِ هُوَ الْوَارِدُ بِأَنَّ هَذَا مَانِعٌ وَفَاسِدٌ أو ضده أو أنه قد أوجب شرطا يكون ويكون سببا. That these are either, these Hukm al-Waḍʿī have the categories of either falling into a sabab, a cause, or a condition, a sharṭ, or a hindrance, a māniʿ. And we'll talk about 2 more after in a bit, inshallah. Who can repeat those to me? These Aḥkām al-Waḍዒyyah.
Sabab, sharṭ, and māniʿ.
Sabab meaning?
The cause. Sharṭ being a condition.
Yeah.
Māniʿ being a hindrance.
Yeah. Sabab meaning a cause, a condition or a sharṭ, and a hindrance or a māniʿ in Arabic. A māniʿ. So,
sorry, what was the other one? One's a cause, sabab, what's the other one?
the sabab, which is a cause, a sharṭ, which is a condition, or a hindrance, which is a māniʿ, or an obstacle or barrier or whatever you want to say. So a sabab, a cause. When we talk about this, we're talking about cause and effect, effectively. Yeah, cause and effect. So a sabab refers to an attribute or quality which is evident from the text. And when that sabab is present, the ruling is present. And when that sabab is absent, the ruling is absent. Okay, so it's a cause for something. Without that cause, the effect can't come into play. Effective is what we're saying. Without the cause, the effect can't come into play. So for example, prayer time. The prayer for dhuhr, the time for the prayer for dhuhr, or any of the prayers coming in, is dependent upon the position of the sun. When the sun is in the correct position, that is the cause. The ruling comes into effect, i.e. that particular prayer comes into effect. So the effect comes about. So at dhuhr, when the sun has passed the zenith, dhuhr time has come in. So the cause is the sun passing the zenith. And the effect is the time for dhuhr, the hukum comes into play. The time for dhuhr has started. And likewise for all the other prayers. When the new moon for Ramadan is sighted, the hilal, that's the cause. The effect is the hukum, which is the month of Ramadan has started, comes into play. When the moon is sighted at the end of Ramadan, that's the cause. The hukum, the effect is the month of Ramadan has ended, we can now start eating and drinking during that month anytime. When a person murders somebody else, this becomes a cause for qisas coming into play, the rules of retribution coming into play. When a person steals, again, it becomes a cause, and the hukum is the rules of qisas or retribution come into play. So the sabab is the cause, and the hukum in this case would be the effect. In each of these examples, if you think about it, the cause is something external to the act itself that's required for that act to become obligatory. So it's something that's external needed for that obligation to come into play. Is that making sense? Yes? So somebody repeat to me what sabab is in their own words. What is a sabab in your own words? Go.
It's something that has to take place for something, for example, so if you have something that's fard that you have to do, something else has to take place, for example, in prayer, like Maghrib time, that fard takes place when the sun sets.
Yeah, exactly. Okay, good. The second type of hukum al-Waḍʿī is a sharṭ, which is a condition. And again, this is something external to the act that must first be met before that act can come into play, or the hukum can apply to that particular act. Again, they say it's an attribute which is evident from the text, and when it's present, the hukum may be present. And when it's absent, the hukum is definitely absent. What's the difference between this and the sabab we talked about earlier?
You said maybe.
So, the sharṭ is an attribute that must be present, and when it's present, the hukum might be present. And when it's absent, the hukum is absent.
Here's might.
Yeah, here's might. What was sabab?
It becomes a prerequisite.
Yeah. The sabab is when it's present, the hukum has to be present. And when it's absent, the hukum is definitely absent. So before the sun reaches the peak, passes the zenith, the hukum of dhuhr prayer hasn't come in, it's absent. It's only when the sun has passed the point of the zenith that a hukum has come into play. So when the sabab is absent, the hukum is absent. And when the sabab is present, the hukum is present. The sharṭ is different. When it's present, it doesn't mean that the hukum is present. But when it's absent, definitely the hukum is absent. Examples. The presence of a valid marriage is a sharṭ for divorce. Yeah? Meaning by this, that just because you are married, you don't automatically get divorced. Otherwise you're in trouble, right? So the very presence of the sharṭ doesn't mean that the divorce has automatically happened. Yeah? So the sharṭ is that we must first have a valid marriage in order for in the future, if a divorce has to come about, for the man to divorce the wife, for example.
Example.
And then for him to divorce the wife, the marriage has to be present. So here, in order for the hukum to take place, for the hukum, if hukum was absent, a marriage is absent, a divorce can never happen. It's an impossibility. You can't divorce somebody you're not married to. But if the marriage is there, it doesn't mean automatically a divorce has taken place. Yes? Is that clear?
So you can say the same for wudu and salah.
Yes. So another example is wudu. Wudu is a sharṭ for the salah. Meaning by this, if I make wudu, the prayer doesn't automatically take place. Right? It doesn't mean that I make wudu, the prayer is automatically taking place. But if the wudu is absent, the prayer can't take place. Yeah, it's an invalid prayer if I was to pray. Hajj, another example. وَلِلَّهِ عَلَى النَّاسِ حَجُّ الْبَيْتِ مَنِ اسْتَطَاعَ إِلَيْهِ سَبِيلًا. That pilgrimage is a duty owed to Allah by people who have the ability to make the journey, to perform the Hajj. Here Allah has made Hajj conditional on what?
Those that have
Ability. So if the ability is present, it doesn't mean automatically the Hajj has happened, right? But if the ability is absent, the hukum of the Hajj doesn't even apply to that person. Yes? So the sharṭ is a prerequisite, if you like, or a condition that must be present before, and it's external to the act, but it must be present in order for that hukum to apply upon the act in the first place. The sharṭ. This is a second type of hukum al-Waḍʿī, or declarative law. And sharṭ and sabab often go together. They often go hand in hand. So for example, murder, as we said earlier, murder is a sabab for qisas, for retaliation, the laws of retaliation applying. But with the sharṭ that a murder was deliberate and hostile. Yeah, it can't be an accidental murder, right? So the sabab for qisas is that murder has happened. But the sharṭ for qisas as well, that goes hand in hand with this, is that murder must have been deliberate and hostile. Otherwise, even in English, what do you call it? Manslaughter, is it? When it's not deliberate, not hostile. So you find actually, it's quite interesting to find when you go through law and jurisprudence in Islam, you see a lot of it reflected in British law as well. And a lot of the subtleties are actually reflected. The contract of marriage is the cause for marital relations, is a sabab for marital relations, having legal marital relations. But with a sharṭ that two witnesses must have been present for that nikah to take place. Okay, so sabab and sharṭ often go hand in hand, they go together. The third one is a māniʿ, a hindrance. It's something whose presence nullifies the hukum. If it's present, it nullifies the hukum. Instead of making it obligatory, it does the opposite. It nullifies it, cancels it out altogether. So, for example, the Messenger of Allah sallallahu alaihi wasallam said, "La yarithul qatil," that the killer cannot inherit. If a person's killed a person he should inherit from, the very fact of his killing is a māniʿ, an hindrance from him actually inheriting from that person. So if a person's been waiting for his father to pass away and he just gets bored, he gets impatient, goes and kills him because he wants the inheritance, in Islamic law that person is not allowed the inheritance in the first place.
So, I was trying to give my own example, but so it makes sense to me. Can I give it?
Let me finish some more examples and then we can give you one, inshallah. A woman wants to pray, and she's about to pray, and suddenly her menses start. Okay? The menses is a māniʿ. That is a barrier that prevents her from praying. Therefore, the hukum of the obligation of prayer is cancelled out altogether for her. So the māniʿ has come into place. Again, this is something external to the act itself. Zakah, but the person has a debt. Again, the debt acts as a māniʿ, a hindrance or barrier that prevents the hukum of the zakat becoming obligatory upon that person. What was your example? Give an example.
Yours are much better.
Go on, let's hear it.
I was going to say, so then if there's nothing available, you're allowed to eat pig if it's for the sake of life.
Yeah.
But then if food becomes available, then that nullifies you eating
Yeah.
pork, right?
Yes, yeah. Yeah, but mine are better long. Within the Aḥkām al-Waḍʿiyyah, or the Declaratory Law, there are two other categories as well that are really based upon the first three. And the scholars differ actually as to whether these two categories fall under this category or the Taklīfī category, which we talked about earlier, but that's not really a big issue for us here today. And the first one is what they call azīma and rukhsah. And azīma is a strict law. It's basically, and most of the rules and regulations of Islam are azīma, they're strict laws. I.e., you must pray, you must fast, you must obey your parents, you can't drink alcohol, they're strict laws. And then we have rukhsah, a concessionary law. A concession has come into place by Allah subhanahu wa ta'ala based upon certain conditions being present. So for example, travelling as the existence of travelling allows the concession of joining prayers, for example. It allows the concession of shortening prayers. It allows a concession in the month of Ramadan for a person not to fast. Likewise for the case for illness and hardship. So all of these are concessionary laws which come into play when certain qualities or when certain conditions are met. So you could say that the sabab for the concession is either travelling or either illness or either hardship. And likewise, the last one in Aḥkām al-Waḍዒyyah is sahih and bātil. Sahih is valid and bātil is invalid. The ruling of acts. So when conditions are met for an act, it becomes sahih, it's valid. And when the conditions are not met, it becomes bātil or invalid. So an act is either, be it an act of worship or an act of, be it a transaction or whatever, it becomes sahih, a valid transaction if the conditions for that act are met, and it becomes bātil or invalid if the opposite happens. So really these last two that they talk about, the azīma and the rukhsah, and the sahih and the bātil, are really based upon the first three. Azīma is a strict law. And rukhsah is a concessionary law.
Why would azīma be classified, or why is there dispute like being classified in the hukum al-Waḍʿī rather than being taklīfī?
Because azīma is basically you must pray, for example, yeah.
But isn't that almost a level above wājib then?
No, for example, azīma is you must pray, it's wājib for you to pray. That's what azīma is, you must pray.
Okay.
Yeah. Or you must fast. Yeah, which and the ruling of that is this wājib for you to fast, for you to pray.
Okay.
But they put it in here because it's contrasted with rukhsah, which is a concessionary law, and that comes about because of asbab, because of sabab. Yeah. And that's why it's put here.
So azīma is like do's and don'ts.
Yeah, azīma is the do's and don'ts, and the rukhsas are the exceptions. Yeah, the concessions, if you like. Right, questions. Menses, as with regards to prayer and marital relations, what category does that fall into? Yes.
Is it called māniʿ?
Māniʿ, which is either taklīfī, which one is it, taklīfī or Waḍʿī? Waḍʿī. So it's a māniʿ, it's a barrier, it's a hindrance. Okay. The Messenger of Allah sallallahu alayhi wa sallam said about the new moon of Ramadan, when you see it, fast, and when you see it again at the end of the month, break your fast. Sabab. So it falls into which category? Sorry? Al-Ḥukm, come on, say it, don't whisper.
That one.
That one. Al-Ḥukm al-Waḍʿī, yes, the declaratory law. Because seeing the moon is a sabab for the start of Ramadan. Okay, I gave you this example already, but Hajj is upon the person who, as the Messenger of Allah alayhi salatu wasalam, we mentioned about the 5 pillars of Islam. Hajj for the one who has the ability to make the journey. Sharṭ, which falls into which category? Okay. The Messenger of Allah alayhi salatu wasalam said, O young people, those of you who have the ability to marry should marry. Those of you who don't should fast.
Sharṭ.
Sharṭ, yeah. Allah subhanahu wa ta'ala says, أَقِيمُوا الصَّلَاةَ وَآتُوا الزَّكَاةَ. Establish a prayer, give the zakat.
al-Ḥukm al-Taklīfī.
Al-Ḥukm al-Taklīfī. And for extra points, which type do you think it's going to be?
One of them.
Wājib.
It's an azima, yes, an azima, yeah.
Wājib.
Wājib, yeah, because it's imperative. Okay. Another one in Surah Al-Isra. أَقِيمِ الصَّلَاةَ لِدُلُوكِ الشَّمْسِ. Establish the prayer when the sun is going down. Sorry? Right? Anybody else?
And far.
And for is both. This ayah contains both a hukum al-taklif and a hukum al-Waḍʿī. So it contains the aqim as-salah, which is a command to pray, establish a prayer. Li-duluki ash-shams, when the sun is going down, is sabab.
And azima.
And it is an azima, yes. It's a strict law. Okay. When we start talking about Aḥkām, is there any questions first before we go to the next section? Any questions on what I've said so far? Yeah.
You know, from the example you gave about the one who can marry, the sabab is for him to have the ability to get married.
Yeah. The sharṭ.
And the sharṭ, sorry. And the one that can't get married is a māniʿ, like a hindrance for him, the ability not to get married.
Yeah, so he doesn't have the ability to get married.
So that's the māniʿ.
That'd be a māniʿ for him. He doesn't have that ability. Yes.
I'll ask you.
There's another one, there's a famous principle that in order to do wājib, and you need to do
We'll
something.
come back, inshallah. We'll come back.
Can I just ask one?
Go on. Is there something on this side first? Okay, go on.
You know, because like I'm a teacher, and when we take our children out to trips, it's very difficult for me to pray my salah because I can never at any point leave.
If it's a fit question, can we just leave it to the end rather than in
That's
between?
what I'm saying.
Yeah, inshallah. Go on.
Um,
Ask the questions during the class about the actual thing we're talking about, and you can ask the things after the class, inshallah.
is it correct to say that the absence of a sharṭ is always a maaniʿ?
The absence of a sharṭ is always a maaniʿ. Yes, yeah. Yeah, so because the absence would mean that the hukum is always absent. Yeah, so it's something that's preventing you from doing the actual thing.
Tayammum will be rukhsa.
Tayammum is a rukhsa, yeah. Some schools actually there's an azima as well, but we'll talk about it. All we need to do is how to do it, really. Right. So, Aḥkām al-Taklīfīyyah. So we've finished the Aḥkām al-Waḍዒyyah. Who can give me the 5 for a gold star?
What was it again?
The 5 categories of Aḥkām al-Waḍዒyyah.
Oh. Sahih.
Yeah.
Bātil.
Okay, that's 1 or 2. Yeah. Sahih and Bātil.
Sabab.
Yeah.
Māniʿ.
Māniʿ. Okay. Sharṭ and
Azima and Nuqsa.
azima and muqsa. So somebody else repeat the 5 to me. Go on.
Sabab,
Sabab,
sharṭ, māniʿ,
sabab, sharṭ and māniʿ. Yeah.
azima,
Azima.
and then also
Begins with the S.
bātil and
Sahih. Okay, okay, Aḥkām al-Taklīfīyyah. These are the ones that all of us, I'm sure, are familiar with. It's the 5 categories of Aḥkām. Something is either wājib, or mustaḥabb, or mubāḥ, or makrūh, or hārām. Al-wājib is basically referring to an obligation. And it refers to a command coming from, it comes in the form of, it can come in the form of a command, or it's a command from the lawgiver. That command can come in a number of different forms, some of which we'll talk about. And the basic meaning of amr or command is a verbal demand that's issued from a position of superiority over those who are in a position of inferiority. And the basic ruling of a command is that it's an obligation unless otherwise proven. So a command and amr is something which is a verbal demand. It's a demand that's come from a position of superiority. 2, it's directed towards those inferior. Okay? And the basic ruling of a command, when it comes from Allah and His Messenger ﷺ, is that it's an obligation, unless otherwise proven. So when we see a command coming from Allah and His Messenger, the first thing we say is that this is an obligation. If you want to prove to me it's not an obligation, show me from the words of Allah and His Messenger an evidence that shows that this is not meant to be an obligation, but it's meant to be something else. So if I wanted to define wājib, give the legal definition of wājib is, they say ما طلب الشارع فعله على وجه اللزوم ورتب على امتثاله المدح والثواب وعلى تركه مع القدرة الذم والعقاب. So they say ما طلب الشارع فعله is something which the lawgiver has required على وجه اللزوم, and it's come as a binding demand. It's come as a binding demand. وَرَتَّبَ عَلَى امْتِثَالِهِ, and acting upon it leads to al-madh wa-thawab. Acting upon it leads to praise and reward. وَعَلَى تَرْكِهِ, and leaving it مَعَ الْقُدْرَةِ, while having the ability to do it, الذَّمَّ وَالْعِقَابِ, leads to censure or blame and punishment. So that's quite a long definition of what wājib is. Normally they say, to make it very easy, if you do it, you're rewarded. If you leave it, you're sinful. That's a very, very simple, simplistic way of looking at wājib. That if you do it, you're rewarded, and if you leave it, you're sinful. This is looking more at the consequences of the act rather than actually defining what wājib in its essence truly is. So when we talk about wājib in its essence as to what it truly is, we say مَا طَلَبَ الشَّارِعْ فِعْلَهُ is something which the lawgiver, who is the lawgiver here? Allah and His Messenger. It's something which the lawgiver requires. And عَلَى وَجْهِ اللُّزُوم, and it's a binding demand. It's not something that where you have a choice in. It's come as a binding demand. وَرَتَّبَ عَلَى امْتِثَالِهِ, and acting on it leads to al-madh wa-thawab, praise and reward. وَعَلَى تَرْكِهِ مَعَ الْقُدْرَةِ الذَّمَّ وَالْعِقَابِ, and leaving it while having the ability to do it leads to blame and punishment. Yes?
Are we going to cover the things that, so if there is an amr, things that make it not wājib?
Yes, we will inshallah. When we talk about mustaḥabb, we talk about the things that are required to make an amr go to make a wājib, what looks to be a wājib act, go to a mustaḥabb act.
And there's no ikhtilaf between what is wājib amongst the scholars, is there?
No, not really. There is some ikhtilaf, which we'll talk about in a bit inshallah, but it's not really talking about the essence of what wājib is. There are many ways, again, this is all linked to Arabic language. There are many ways in the Arabic language by which we can discern whether something has come in the form of a command or not. And the first is the imperative in the Arabic language. أَقِيمُ الصَّلَاةِ, establish a prayer. This is an imperative. فَلْيَتَّقُوا اللَّهَ وَلْيَقُولُوا قَوْلًا سَدِيدًا. فَلْيَتَّقُوا اللَّهَ وَلْيَقُولُوا قَوْلًا سَدِيدًا. Fear Allah and say an upright word, speak an upright word. Both of these are imperatives. Again, it's Arabic language that tells us it's an imperative. Use of the word amara, command, just the very word amara, to command. إِنَّ اللَّهَ يَأْمُرُ بِالْعَدْلِ وَالْإِحْسَانِ. Allah commands justice and good treatment, or good deeds. إِنَّ اللَّهَ يَأْمُرُ, using the word amara. إِنَّ اللَّهَ يَأْمُرُ بِالْعَدْلِ وَالْإِحْسَانِ وَإِيتَاءِ ذِي الْقُرْبَى وَيَنْهَى عَنِ الْفَحْشَاءِ وَالْمُنكَرِ وَالْبَغْيِ يَعِظُكُمْ لَعَلَّكُمْ تَذَكَّرُونَ. That Allah commands with justice and goodness, and to give to one's kindred. And He forbids, وَيَنْهَى, and He forbids indecency and dishonor and insolence. He admonishes you this in order for you to take heed. So, either the imperative, or using the word amara, or using the word kataba in Arabic, kataba, to decree or to make obligatory. كُتِبَ عَلَيْكُمُ الْقِتَالُ وَهُوَ كُرْهٌ لَكُمْ. That fighting has been made obligatory upon you, has been decreed for you, even though you may dislike it. Because it's possible you may dislike something that's good for you, and it's possible that you like something which is bad for you. Allah knows and you do not know. So kataba, farada is another one, farada, which means to make obligatory. So again, repeat to me, somebody who can tell us the four, these are the four I want to talk about. I just want to mention, there's many, many forms, but these are four of them. What are they? The imperative, yeah?
The word amara.
The word amara, the word kataba, and the word farada.
What about qada? وَقَضَى رَبُّكَ?
And qada is mentioned as well. I mean, there's loads, as I said, there's lots of them. There's lots of them. You find when we talk about obligation, you find that often you find something, either somebody saying it's wājib or somebody saying it's fard. And in the view of the majority of scholars, these two are synonymous terms. Fard and wājib mean the same thing. Fard and wājib mean the same thing. In the Hanafi school of thought, and in one narration from Imam Ahmad, they mean something different. So they said that fard means something which is established from the Quran or mutawatir sunnah, i.e. something which is definitive, is qat'i, is definitive. And wājib is what's established by something which is not definitive. So it's going to be the ahad hadith, if you like, the individually narrated or singularly narrated hadith of the Messenger alayhi salatu wasalam. So the fard is something established by mutawatir, definitive evidence. And the wājib is something established by non-mutawatir, definitive evidence. If you reject a fard in their views, you become a kafir. If you reject a wājib in their view, you don't become a kafir, but you are sinful for rejecting it. But the view of the majority is that they both are the same.
Can you give an example?
Yeah, so witr, yeah. Witr for the Hanafi school is, they say that it's not established by a mutawatir hadith. So for them it's wājib, not fard. Okay? Recitation of al-Fatiha in salah, for them it's not established through mutawatir hadith. And therefore for them it's wājib, not fard. Meaning by this, if you don't recite it in the prayer and recite another surah in its place, the prayer is still valid. It doesn't become invalid. If you reject that you should recite Fatiha in the prayer, you don't become a kafir in their view. In wudu, madmada and istinshaq, rinsing the mouth and snuffing the nose, not established by mutawatir sunan. So you find them saying it's wājib, not fard, for in wudu. It's wājib, not fard.
But in their eyes you'd be sinful.
Sorry?
In their eyes.
In their eyes you would still be sinful. For not doing both acts, you would still be sinful. So either fard or wājib, you're still sinful for not doing it.
But the action would be sahih.
But if it's wājib, the action will still be sahih, yes. If you left out a wājib, the action will still be sahih. Yeah. What's important for us to recognize also is that something which causes confusion is that the term wājib was used in a hadith and narrations from the Salaf. But the technical sense of the word wājib was only acquired later on. So in the hadith of the Messenger of Allah sallallahu alayhi wasallam, and in the narration they talk about wājib from the Salaf, they're talking about it in this linguistic sense, which is something which is important to do, if you like, something which you should do, but it's not talking about it as this is fard, if you leave it you're sinful. So a famous hadith, ghusl on the day of Jum'ah is wājib upon every Muslim. Okay? This hadith doesn't mean that this hadith can't be used as a proof that it's obligatory to make ghusl. I'm going to leave the actual ruling aside, I'm not concerned with that. This hadith can't be used to prove that ghusl is an obligation on Jum'ah, because it's being used in the linguistic sense, not the technical sense, the word wājib in this hadith. So in the hadith, in the words of the Messenger alayhi salatu wasalam, the term wājib was not used in the sense that it was used by later scholars, i.e. if it's obligatory, if you leave it, you're sinful. Did you have your hand up? Yes?
Is there any proof for that?
Sorry?
Is there any proof for that?
It's a good question. What's the proof for the fact that this was a linguistic usage and not a technical usage? generally you find, I mean, I'll look into it for you, inshallah. Generally you find that all the scholars talk about this fact that it's not, that this term was not used in that sense, in a technical sense, at the time of the Messenger, it was a later development.
I think some could argue with Arab, the way the Arabs understood the language.
Yes.
Because the formulation of the technical term came years later.
Yeah.
So it's to do with how the other Arabs
Would have used and
like even
understood
today,
language.
the Arabs might say, يجب علينا, we should go.
Yeah.
ينبغي. It doesn't
Yeah.
mean you have to do it.
Yeah.
Okay. So you see, wallah.
Could you use the narration of man like Allah who came to Jum'ah without having made ghusl?
Yeah, so that's talking about the actual discussion about the actual act of ghusl itself, but we're talking about the linguistic usage of wājib. So you could maybe say that he understood it not to mean wājib, not obligatory by the fact he came to Jum'ah without ghusl. I'll look into it for you next week, inshallah. There's a lot more to do about wājib and the other four. We're going to carry on next week, inshallah. I think there's enough information for today. If there's any questions, they can be asked.
Can I ask my question about my school trip?
Yeah, go on. Sorry, if there's any questions first on the topic. Okay?
So you know I'm at school and I take kids on trips and I can't at any point leave them alone. So my question was regarding rukhsah. Who determines the rukhsah for me? Do I decide, you know what, I actually can't leave these children, but I'm obliged to pray, so I'm going to combine later or I'm going to shorten later?
Yeah, so in terms of making these determinations, a lot of the time it's left down to the individual to make the decision, because a lot of times you can't actually... the ideal course is that you refer back to somebody who knows. So you phone somebody up, you ask a scholar or whatever to find out what the ruling is in the situation. If you can't do that, then the only recourse left for you is to fear Allah as much as you can. Make your own judgment call on the situation. I can't leave the kids unsupervised at all. It's an impossibility. There's safety issues. There's lots of different issues you have to consider. Make your judgment call. And if it is difficult and you can't do it, then the concession of joining the prayers for you could apply.
Yes. I have a question, but it's controversial and maybe it's not best to this. But many people use the argument, Uṣūl argument, about khilafah. And they say khilafah is conditionary and what's it called? So in order to make khilafah, that's which is a wājib, it's wājib on us to make a group, political group, to get the khilafah.
Yeah, let's leave that discussion for another time, inshallah.
Could you just go over the meanings of wājib and fard,
So you mean the differences between the two?
The difference.
Yes. So according to the Hanafi school, and as I said, one narration from Imam Ahmed, the fard is an obligation established through definitive sources. And definitive sources in this terminology refers to the Quran or the mutawatir sunnah. The Quran or the mutawatir sunnah. And wājib is an obligation that's established by non-definitive sources, which basically refers to non-mutawatir sources, i.e. ahad, ahadith. To leave both of them is a sin, but to deny the fard is an act of disbelief, and to deny the wājib is not an act of disbelief. Is that okay?
So leaving both of them is a sin, but
Denying the
fard
fard
is an
act of kufr.
and wājib is not.
Yeah.
I think this brother was first.
So go on.
What was kataban farad?
Kataba.
Kataban farada.
Kataba means to, if you like, to write or to decree. And farada, again, to make obligatory. Or appoint. To appoint or to make obligatory. Or to declare as well, decree as well.
Questions from upstairs?
Sorry?
Questions from upstairs?
If there's any questions from upstairs, can they please be written down and passed downstairs?
Couldn't it be argued that the Hanafi position is a more merciful position?
They actually, Imam Ghazali and Ibn Qudamah and many other scholars, they said that really the difference here is one of pure wording. There's no real, if you look at the meaning of both, there's no real difference here at all. It's just one of wording and preference of terminology. Because they said that even those scholars who say wājib and say wājib and fard are the same thing, they still differentiate between a wājib that's established by definitive sources and a wājib that's not established by definitive sources. Because in fiqh it becomes important to make this differentiation, especially when you have to make a choice between one or another. Yeah, where you're given a choice between two obligations, and you have to choose one of them. One of the ways of deciding which one to choose is the one that's established by definitive sources. Yeah. And there's lots of different cases like that. Sorry.
But the difference is actually quite extreme, because by rejecting one of them, yeah, you can go outside Islam.
Yeah, but even those who said that the wājib, there's no difference, they will still say the same thing. They will say those obligations established by definitive sources, if you reject them, you're a kafir. And the other one is. So they're saying that the ruling effectively is the same in both camps. And meaning-wise, they're both saying the same thing. But they just decided to use different terminologies. That's all it is. And it's actually very important. You find that scholars will often use different terminologies. And it's not so much for us to really get involved in argumentation about which terminology is better. First of all, look behind the meaning of the words. What are they saying themselves? And if the meaning is the same, we don't really care about terminology after that.